Swayam Prabha. Digital India. Educated India.
Dear students, welcome to the class of Transfer of Property Act. This is the third lecture in Transfer of Property Act. Prior to this, I have discussed about the property, concept of property, types of property and definition of transfer of property. In this lecture, I am going to discuss about what cannot be transferred. So, there are certain things or rights which has been given in statutes or Transfer of Property Act that they cannot be transferred, they are not the subject matter of transfer under the Transfer Property Act. So, I am going to discuss this in detail in this lecture. So, topic I am going to cover is this general rule of transferability of property, then section 6 of the Transfer of Property Act, space section is chance of an heir apparent, legacy, other possibilities of like nature, comparison between section 6A and section 43, easement, restricted interest and right to sue and some other part which is covered under section 6. So, I will start with the general rule of transferability. What is the general rule of transferability? General rule of transferability is that property should always be in form of transferable things. That means, it cannot be restricted, that it cannot be transferred and for long time it cannot be restricted. So, the value of property as well as for the betterment of property and betterment of society, it is always required that the right related to property should move on. It should not be restricted to a single person and it should not be restricted in perpetuity. It will be harmful for the society as well as for the property itself. So, the general concept is that there must be always transfer of property, but there are certain rights which may fall under the category of property which are debarred from transferring. Okay. So, in that way this section 6 is about going to give you a picture that which cannot be transferred in any circumstances. This transferability of property is based on one maxim, that is alienatio rei prei fortuit. This juri exerendi means, it is the meaning of this is that alienation is favored by law rather than accumulation. So, accumulation of this wealth in the form of immovable property should not be in one hand. So, it should be always movable. So, general rule of Transfer of Property Act is to promote transfer, promote alienation, that means movement from one place to a movement from one person to other person these rights. We can correlate also with the Indian customary practices that the goddess of wealth Lakshmi is always called as movable. That means, it wealth always should move from one hand to other, then there will be prosperity in society. Otherwise, if it will stuck in one hand, then it will be against the public policy, against the society, against the property and all. So, this is the general rule, but even being this general rule, there are certain exceptions which has been created under a statutory provision under section 6. So, section 6 says that the property of any kind may be transferred except exception given in this section. and this section mention number of exception, that is from clause 6a to 6i, and list a number of cases, number of situation, number of things which cannot be transferred from one person to other person. This is non-transferable at all. So, I am going to discuss one by one. Before that, there is also important that once we are going to discuss about the transferability of property. So, what are the general condition of transferability of property? What are the basic requirement for the transferability of property? So, accordingly, it says that property must be transferable, then object or consideration of transfer must be lawful. Then when you are transferring any property, because it is a kind of contract. So, transfer of property is also a kind of contract. So, when you are going to transfer the property, that is also a kind of contract, and in that way it must be lawful and according to the permissible limit. So, transferee must be competent, that is also the ground of contract, that the party of the contract must be competent. Here transferee must be competent, that he must not be legally disqualified to take transfer. The next is transfer must not oppose the nature of the interest of affected thereby. That means, transfer, whatever the transfer is going to be done, that should not be affected against the interest or nature of the property itself. That means, for what purpose this property is, or what is the basic characteristic of that property, nature of that property, against that it cannot be transferred, and I will explain all these things in detail later on. Next point is transfer must be competent, transferor must be competent to transfer, and it must be made in the prescribed format, whatever the rules and regulation has been laid down, criteria whether the registration is necessary or not necessary, what is the proper format for that. Okay. So, all these must be followed at the time of transfer of property, immovable property or movable property. There are certain kinds of limitations, limitation in the sense that if it is more than 100 rupees property, then registration has been made must in case of immovable property. Okay. And in same way, there are other condition has been laid down. So, these are the procedural requirement, but this procedural requirement also become very specific when we are going to deal with the specific kind of property. So, it must be also followed in that sense. Now, come to the section 6. Section 6, that is about the giving the list of non-transferable things. Within that non-transferable things, this first is space successiveness. Space successiveness means an expectation of succession. It is a possibility of getting property in future through succession. That means, there is expectation, it is a kind of thing which say that someone is expecting that okay, in future through succession the property will come. So, this is not a right, it is expected right which is going to be generated in future. So, expectation is not transferable, expectation is not a right, because it may come, it may not come in future. So, in that way it has been said that this space successiveness requires 3 criteria. First, the chance of an heir apparent succeeding to an estate. Second is chance a relation obtaining a legacy on death of kinsman, or any other mere possibility of like nature. So, in these 3 circumstances it has been said that there may be creation of space successiveness. So, this clause says that space successiveness is not transferable because it is a kind of expectation. So, this kind of expectation for all these 3 expectation, that is chance being here apparent in succeeding estate, as well as chance of relation obtaining a legacy or mere possibility of like nature, I am going to discuss in detail one by one. So, first is a chance of heir apparent. What is the heir apparent? Heir apparent, it is itself nomenclature suggests that it is a apparent, it is not a real. That means, any person who is apparent heir means he is not a real legal heir. It is only expectation that in future he or she may be legal heir of some person and property will come to him or her in future. So, this expectation does not create this legal heir or a real legal heir. So, heir apparent is the person who would be the heir if he survived the propositus and if the propositus die intestate. Propositus means the person who is going to give the property or whose property is going to be succeeded, that person is propositus. So, if the propositus is going to die and that there is he is going to die intestate, then only he will become this legal heir. Prior to that, he is only an kind of apparent heir. Next point in this is the propositus is a deceased person. Then the term apparent heir is taken from English law. What is the term of this apparent heir? This has been developed through a maxim, nemo est heiris viventes. That means, no one is the heir of a living person. So, it is surprising that no one is heir of the living person, that okay, living person will not have heir. Generally, we used to say or used to think that the child of the person is heir, that he will inherit the property after the death of the person. But this heir, that is when he will take the property, he will succeed the property, is always subject to the death of that person, propositus. Okay. So, it is said that no one is the heir of a living person. So, person if he is living till then, no one say that he is legal heir. Legal heir means the person has died and you are claiming it as a legal heir, that means you are the person who can succeed the property of that person, then only this principle will come. So, concept of legal heir is very important. It should not be confused that the person is alive and the their children's, their siblings are falling under the category of heir. Certainly, they are here in a colloquial language, but actual here they will come, that means they can raise the issue, they can claim the rights after the death of propositus. The next point is the chance of an heir apparent to succeed an estate is only an expectation that may be defeated by the act of some person having present power to dispose of the property. So, it was observed in various cases, not in one case, but various cases, that if the person has a power to dispose of during his lifetime, then he can dispose of the property and heir will not get any penny or any part from that property. In that way, it can be said that the person is not a heir, things has been disposed during the lifetime of the propositus and heir will get nothing in that case. So, it is a mere expectation. So, being a mere expectation, no one can claim that I am going to transfer my future rights of legal heir from the present time and in future you will be taking the benefit from that, or the person or purchaser will take the benefit from that. That is not allowed. This type of agreement will be void ab initio according to the section 6 of Transfer of Property Act. Okay. Then chance of an heir apparent. This chance of an heir apparent, it is an undisputable law. It has been said that no one can have any estate or interest at law or in equity, contingent or others in property of living person to which he hopes to succeed as a heir at law or next kin of such living person. What I have already explained to you, that in that case no one can claim like that. During the lifetime of such person, no one can have more than a space successness and expectation or hope of succeeding to his property. In India, this is one of the best example, that in India The reversionary right of under Hindu law are merely a chance of getting properties, and that is why it is space successiveness. What is the reversionary right? Reversionary right is generally it is right of a widow. That means certain part of a Hindu certain part of the Hindu property in a joint Hindu family is owned by widow, and after the death of widow, this property will go to the their heirs, and if they are not heirs, then the original person to whom the property has been vested to the widow. So, in that case, any person that this reversionary right is that in future after the death of widow, the property is going to come, and then you are going to deal from the present time itself. It is also it will fall under the category of space successiveness. So, the reversionary right of cannot be transferable and it cannot be transferred. So, in Amrit Narayan versus Gaya Singh, the Privy Council observed a Hindu reversioner has no right or interest in presenti. Interest in presenti means the present interest in the property which the female owner hold for her life until it vests in him on her death. Should he survive her, he has nothing to assign or to relinquish or to even transmit to his heirs. His right become concrete only on her demise. Until then, it is a mere space successiveness. That means, unless and until that widow is not going to die, okay, the any right in the property which is vested, which was vested in that widow cannot be transferred to the person or cannot be transferred to the person who is going to succeed after the death of that lady. So, this has been kept under the space successiveness. So, expectation of getting property through succession is a space successiveness which is non-transferable in Transfer of Property Act. The next is legacy. Clause B provide that a chance of relation obtaining a legacy on the death of kinsman is non-transferable. Legacy means again expectancy of getting certain property under a will. Certain property under will, chance of legacy. Chance of legacy means you that means person has made a will, and in will if some person is going to get the some part of property. So, he is knowing that my name has been referred in this will, and after the death of that person, he may be the parents also, he may be any relative also, any person may be there. So, the person who has made the will with the consent of the person to whom it is going to be transferred after his death, that okay, I am going to make a will of this property and you will be the successor after my death through this will. In that case, what will happen? The person to whom the this property is going to be divested after this death of the person will also create a expectation in the mind of the person to whom in favor of whom that will has been made. So, if that person is going to say in future, okay, that I am the part of that will, there is a share, with the share is going to come after the death of that particular person, then I am going to sell it or transfer it to someone else. So, in that case, because it is not a right completely came to that person, but it is a mere chance that he that particular right may divest on the death after the death of this executor. So, in that case, it has been also kept under this space successiveness. He cannot do like that. So, the legacy is also if the property is coming through the legacy, that is also prohibited under this transferable. That means, it is non-transferable. So, legatee under the last will only will get the legacy. This is the rule, that legatee under the last will, if there is more than one will, then the last will prevail and that person will get. So, suppose the some person was legatee in the first will. So, first will person will have also a kind of expectation against that will, second will has also some legatee. So, and this it is not necessary that all will first, second or third whatever has been executed by the person, that will be known to the legatee. Sometimes it's happened that sometimes they do not disclose to whom they are making it. After the death, person will know that I was the nominee in that will. So, in that case what will happen, if someone is knowing in some will and someone is not knowing in another will, then this expectation will create problem. Okay. So, that should not happen. The rule is very clear. The person who will be mentioned in the last will of the executor, only that person will be the proper legatee of the property of executor of the will. So, expectancy to receive legacy in uncertain, because the legatee may or may not survive the testation, and the testator may have changed the name of the legatee in his last will, as I explained. So, the chance of legacy has been made non-transferable. That means, where there is uncertainty about the coming the rights in future, that has been kept away from the list of transfer. Okay. Then third point is any other possibility of like nature. Any other possibility of like nature means what? That it has been included in clause 1, that if there is any possibility of possible property or interest which is as uncertain as successness or legacy, that too will not be transferred. Okay. So, any property that is merely a future uncertain possible interest should not be made transferable. Okay. So, here it has been given the future interest what you are going to gain, that cannot be transferred. An example here is given of the fisher net or crops in field or crops in orchard, that the something will happen in future, and on the future property you are going to make a transfer, that because you know that the right accrued from the immovable property is also immovable property. So, that are the subject matter of transfer properly, but the future accrue of the property, that something will come in future and those things you are going to sell in advance, then it will be non-transferable. That means, you cannot transfer in future that the something is going to be expected that this in this season this much fruit will come, and in that way you are going to make a deal with another trader. So, these kind of practices are prohibited under this Transfer of Property Act, because what is the main element in all these, you will see this is all about the uncertainty. So, these uncertainty creates problem that they are not going to become the subject matter of transfer under the Transfer of Property Act. So, next is right to receive future offering. Now, I am going to discuss the like nature of possibility. Okay. So, under the like nature of possibility is right to receive future offering. Okay. Future offering means it is whether the right to receive future offering can be assigned or not. Okay. So, future offering means what? Future offering in temple it is mainly. Okay. That if in temple whatever the offering will come into the future, whether any priest can make a transfer of this title or right to another priest or another person or another legal person, and whether it will be a valid transfer or not. Okay. So, there are diverse opinion over it, and there are certain scrutinization of this concept itself, that what is the future offering, whether it is certain future offering or uncertain future offering, and accordingly the court had decided various cases. Okay. So, in the view of the Calcutta High Court, what Kolkata High Court says that the right is a mere possibility because it is uncertain. Then Calcutta High Court was not in favor to say that the future offering will fall under the category of transferable nature, whereas Allahabad High Court held that the right to receive offering is not certain, or because offering large or small are bound to be made in a certainty and not mere possibility. That means, if offering are certain, that okay, amount may be vary, that means a small number to the large number, then future offering. Just take the example of big temples of India. So, in big temples of India you cannot say that offering will be that means uncertain. Amount may be uncertain, but certainly offering is not going to be a stop. So, in that case those rights in those temples will become transferable. Whereas, if there is a very new temple in a remote area, and the possibility is that what kind of the whether it will start or not, it will start, and in future, in the present you are doing any kind of transfer of the rights for the future itself, that completely dependent on the nature of offering, whether it is going to be permanent or it is going to be uncertain. Okay. So many factors will come to determine whether it is certain or uncertain, which kind of the organization is running the temple, what is the value of total worth in value of the particular temple, what are the past practices, past offering and all, continuous offering. So, all these things will be taken into account, then certainty and uncertainty will be determined, and if there is uncertainty in at any stage of offering, then it will go under the non-transferable, otherwise offering will be also transferable. So, the Supreme Court settled the law by holding that the right to receive the offering being coupled with the duties other than those involving personal qualification, therefore transferable and could be inherited. What it say that right to receive the offering being coupled with duties other than those involved personal qualification. That means, if any person is getting offering in lieu of certain duties, which is not the part of the professional qualification as required, then those offering will be transferable in nature. What is the meaning? That if that priest is getting offering because he is doing certain duty in temple, okay, and in lieu of that duties those offerings are coming. So, in that way it has been said, because person is performing duty, in lieu of that there is a consideration of that duties. So, it is a kind of the permanent nature, because the person is performing duty, if he will go, other person will come, okay, and another person will go, third person will come. So, continuity is there, certainty is there, and offering will also continue. So, in that case it has been said, and it is in addition to the professional qualification, because this offering is not dependent on the professional qualification. This offering is completely dependent on the duties. In that way it has been said by the Supreme Court that it will fall under the category of transferable property. Then next is difference between section 6A and section 43. 43 is generally called feeding the estoppel by grant. So, what is the difference between these two? First of all, because section 6A you have now well aware with the specificness. First, now you know about the feeding of the estoppel by grant. So, section 43 says, where a person fraudulently or erroneously represent himself that he is authorized to transfer certain immovable property or professes to transfer the such property for consideration, and that is fraudulent in nature. Okay. Then such transfer shall at the option of the transferee operate on any interest which the transferor may acquire in such property at any time during which the contract of transfer subsists. That means, if take the example, if I am the person who have given this kind of assurance to Mr. A, that see Mr. A, I have this kind of the property, one house, or I have this kind of right in that property which is exclusive to me, and I am going to give you, and I took the consideration in lieu of that right of that transfer of that right, but actually that right was not in existence. Later on, anyhow that rights came to me and that contract is still in existence. So, in that case what will happen? If those property against whom I have taken consideration, okay, that rights if it will come to me, then I am bound to execute the contractual obligation which I did with Mr. A. That means, contractual things had happened earlier, later on the property came to me, and because this is a estoppel, okay, feeding the estoppel by grant, that means the things has been done on the assurance that this is mine property, he has given consideration. So, I will not go back of my promises. Okay. So, if the things will come to me, then I am bound to act on my promises, even though it was a fraudulent promise. But now the things is possible that I can do that, the properties has came to me. In that case, I will be responsible for doing that. So, this is in section 43. Whereas, in case of section 6A space successness, here person is also transferring space successness. Okay. And it is also if he is knowing that it is a space successness and I am going to transfer. So, is there any conflict, because here will be also fraudulent thing that in future this is going to come and I have did already transfer to it. In 43 it is also saying that I did it for consideration, but later on it is coming to me. So, the question was raised whether it is in conflict of section 6A is in conflict of section 43 or not. So, here it has been said that when a person transfer a property on the representation that he has a present and transferable interest in the property, but in reality he has no title, and the transferee on the belief of that representation takes the property for consideration, transferee will be entitled to the property if subsequently the transferor requires the property and contract is still subsisting and has not been cancelled, that is section 43. Now, the difference. Okay. Difference is what? That in case of space successness, this is section 6, the chance of an heir apparent is to get property in future is a non-transferable interest and it is void ab initio. Okay, non-transferable since the beginning itself, but in case of section 43, it validates a transfer made without title when the such transferee subsequently acquires the title, meaning thereby in one case there will be no transfer at all, in another case if the property will come then it will be transfer that person is bound to transfer, otherwise he will be responsible for fraudulent case. So, there is a difference between these two sections. One directly says that first it is bound by that and any kind of misrepresentation will not validate a space successness, whereas in case of misrepresentation in section 43, but the subsequent action, subsequent facts, if it is coming that property now came to the person who has given the promise, he is bound to fulfill that promise if contract subsists. So, that is the main difference between these two. So, this is the leading case where the Jumma Masjid versus Kodimanyandra, this 1962 Supreme Court case. In this case, what was happened, that the Supreme Court has set the rest of the controversy between section 6A and 43 by holding that there is no conflict between two sections and both may operate simultaneously. Okay. The fact of this case were that an heir apparent sold his would be share in the joint property to Masjid for rupees 300. That means, he was a legal heir and a space successness, he has sold his share in 300 rupees. Subsequently, when the transferor became entitled to his share as legal heir, Masjid invoked section 43, that now space successness, when you did this agreement with the Masjid, at that time there was a space successness, but the later on share came to that person. So, if the share came to that person, then 43 will apply, and Masjid has argued on the basis of 43, because now you are bound by the estoppel. So, question, and he has pleaded that because the space successness is a void ab initio since the beginning itself, because that agreement is void ab initio. So, in that case, if the agreement is void ab initio, there is no question of section 43 in this case. So, I will be not responsible for that. So, it was contended on the behalf of transferor that interest transferred was a space successness and the transfer of which was void ab initio under section 6, whereas in 43 could not be made applicable to validate the transfer. What the court observed in this case? The court observed that section 6A was a rule of substantive law, whereas section 43 is a rule of procedure, that is evidence. Okay. So, it make no difference in its application whether the defect of title in the transfer arises by the reason of his having no interest whatsoever in the property or of his interest therein being an expectant here. So, here it has been said that there is no difference. One is the rule, estoppel is the rule of procedure. Why rule of procedure is that it is a kind of, because it is a matter of evidence, that once you have said earlier, you are bound by your promises. Okay. Whereas space successiveness is substantive law. Space successiveness is substantive law. So, it is very clear that the substantive law will prevail or procedure will prevail. So, the things which is void ab initio, since the beginning itself, how a procedure can make it valid? It is not possible. The things which are void ab initio, then this procedure will be procedure will validate that substantive law. It is not possible. So, the contract will remain invalid because it was a space successiveness when it has been done. This section 43 cannot cure, but both are independent, they stay always apart. It cannot be said that they are contrary to each other, because both are not on the equal footing. One is the part of substantive law, another is the part of the procedure. Then next clause in section 6 is about easement. Okay. Next clause is about easement. What is easement? Easement is a kind of right. It is called easementary right. So, it is a kind of right which is always attached with immovable property. Okay. It is called easementary right. So, third exception in the general rule is that transferability is given in clause C, which says that easement cannot be transferred apart from the dominant heritage. Now, there are two concepts here. One is easementary right, another is dominant heritage. What is the dominant heritage? That means, if on immovable property, if there is a beneficial right, then they are called as dominant heritage. Those rights are called as a dominant heritage. That means, if I have a purchase of property, flat, shop, building, whatever it may be, then I will have right over that property to use properly for my own benefit. Then it is dominant heritage, that right is dominant heritage. With that dominant heritage, these easementary rights will come by default. By default means that without those easementary right, I cannot enjoy my property to the fullest extent. Suppose I have a land, but there is no way to reach on that land. How can I will use my land, or we can utilize that land? So, right of the way to reach up to my land is my easementary right, because without reaching up to that part, I cannot use my land. In same way, no one can restrict my easementary right, just like light, water and all things, if in violation of my right itself. Okay. So, directly they cannot do like that. So, it has been said that when easementary right is going to be transferred, so easementary right cannot exist independently. Easementary right is always with immovable property. It cannot be separated, it cannot be apart at all. Okay. So, it is like that you can suppose you want to transfer a pond. So, once you are transferring the pond to other person, then the person, the purchaser will have a right to fetch the water from that pond, because it is easementary right related to the pond itself, because the pond is known for that purpose. So, whoever will purchase the pond, whoever will purchase the well, whoever is going to purchase the land part, whatever the right will come through that immovable property, person is going to enjoy that. So, that kind of the rights cannot be prohibited and or cannot be transferred under Transfer of Property Act. So, in simple word, easement is a right which exists for a beneficial enjoyment of a land and its exercise upon the land of another person. Okay. Then further it says that the land or the tenement for both the beneficial enjoyment this right is exercised is known as dominant heritage, I have already explained, and the land or the tenement upon which the right is exercised is known as servient heritage. That means, if there is certain kind of burden, loan or something on the that particular immovable property, that means it is in negative sense that you have a certain burden, you have a certain kinds of things which you will have to clear over that, then it is called servient heritage. Otherwise, if you are going to utilize that particular building independently with fullest extent, then it is dominant heritage. Suppose I am going to purchase a building on which there is a loan, so it will be servient heritage. Okay. Then easement is an incident of ownership of the dominant heritage. It is a right attached to the property, it has no independent existence. That means, easement rights cannot exist independently out of the property itself. Therefore, it cannot be detached from the dominant heritage and transfer separately. So, there is no possibility that you will take it out and then you will sell. You cannot sell any well without water. Okay. You cannot say that okay, you will sell the well and you will sell the water independently. Both right cannot be separated. The well belongs to another person and the water of the well belongs to the another person. The person who will purchase the well will have a right over that water also. So, for example, A, who is the owner of a house, has a right of way over the land of B, which is adjoining to his land. A transfer his right to way over the land to B to C. Only the rights of way has been transferred, not the land. A cannot do this because easement itself is not a property that can be transferred. So, any person only the easementary right belonging to a particular property cannot be transferred. When the property will be transferred, this will be automatically transferred through that property itself. Then if A transfer his house to C, then the right of easement attached with his house will also go to the C. Okay. That means, without easementary right, this immovable property cannot be transferred. That means, both are completely inseparable. Without without any without any gap, without any kind of bifurcation, they are always with each other, and whether it is going to be transferred, they will transfer together, and if it is going to be purchased by other person, that will go to the other person together. So, there will be no bifurcation that it can be transferred, easementary right can be transferred to Mr. A and immovable property will be transferred to Mr. B. So, easementary right is not transferable at all. Now, come to the restricted interest, clause D of section C. What is restricted interest? It says that the fourth exception within the section 6, an interest in the property restricted in enjoyment to the owner personally cannot be transferred by him. This means that the person rights or interest which is only for his enjoyment cannot be transferred by him. What is the meaning of this? Meaning says that if any property is given to a person, any property is given to a person for a limited purpose, that means use this property for your personal use. If that person is going to use the property for personal use, then he cannot transfer the property with whole use. Okay. Restricted interest is in the sense that restricted interest cannot be transferred. That means, for what purpose it has been given, with a limited purpose it has been given, that things cannot be transferred. That means, here it has example has been given that A gives a land to another B for his personal use only, B cannot extend that use of the land to any third person. Transfer of such interest would defeat the whole purpose of restriction, because transfer is possible with restriction. Just like take the example of lease. If I am giving the lease and in condition that there will be not sublease. So, if the person is doing sublease, that means lessee is going to sublease my property, then it will be the against the contract. I will have right as a lessor to break this agreement. So, in that case it has been said that when there is a restricted right, this restricted right will be non-transferable at all, that cannot be transferred. So, it may, this restricted right may be of any form for any condition, whether it is in the form of mortgage, in case of lease, okay, where there is a requirement of a space, that means absolute in nature, that means whole things you are transferring it, then it will go with the all. Just like in the case of sale, when we are doing a complete sale, then the person will have no restriction over that, no, there will be no condition, there will be no any kind of meaning thereby that the seller is not going to put any restriction, any kind of restriction on the property. Then it will go to the purchaser, and purchaser will purchaser is going to enjoy that property up to the fullest extent. It is okay. But if there are certain limitations that okay, this property belongs to you, but that part is not accessible to you, okay, that part I am not going to give you. So, in that case, whenever he will transfer, he cannot transfer this restricted interest. Restricted interest will always restricted in nature, and it is not the subject matter of transfer at all. So, it is open to the donor of to the transfer by gift, title and the ownership in the property, and at the same time it reserve its possession and enjoyment to herself during her lifetime. So, that is possible that I can gift my property to my grandson, but at the same time I can say that during my lifetime I am going to use it, and after my life my grandson will use it. So, that is a kind of restriction. So, once my life will be over, then after all the rights related to that will go, but prior to that only there is a kind of things that my wish is that till my life it will belongs to me, only after my life it is going to the hand of grandson. So, in that way restricted interest cannot be transferred. Then next point is that there is no provision in law that the ownership in property cannot be gifted without its possession and right of enjoyment, okay, merely because the donor mother had reserved the right to herself possess and enjoyment of the property gift did not render the gift deed in favor of the minor ineffective. That means it will be the valid one. Okay. So, under this clause, religious offices like those of the mutually of the Waqf or Mahant of a Mutt, right of preemption and service tenures are included under this restricted right. That means preemption right. Preemption right is what? Preemption right is like that, if in case of joint family, that if someone is going to sell his part, then it is the preemption right of the family that first of all, if their right will prevail to purchase it. If any member of the family is not going to purchase, then only the co-sharer can sell outside the family, because it is in the interest of the family itself that the family property will remain in the hand of family. If the member of the family is not going to purchase, then only the co-sharer or party will have right to go outside it. So, it is a kind of restriction by law itself that you cannot sell if the family member wants to purchase it. Next point is was that in case of this rights of Mahant and this Waqf. So, all these will fall under the category of restricted interest. Then a trustee cannot alienate his office because his office is based on personal confidence. Okay. Emoluments attached to the prestige office cannot be transferred. A trustee cannot alienate his office. That means, a trustee cannot transfer his office to other one, because his office is based on personal confidence. Personal confidence means what here? Personal confidence means what here? That the person who has become the trustee, that means the member has certain kinds of trust with that, or he is enjoying that trust and managing the property. So, his office is based on personal confidence, okay, and in that way he cannot transfer. However, where the right to receive an offering made at the temple is independent of obligation to perform service involving qualification of personal nature, which I have already explained it. Then this is about the right to future maintenance. This has been added in 1929. Future maintenance means what? That means future maintenance that person is going to claim in future about the maintenance of their own. Okay. So, right to future maintenance is for personal benefit of the person to whom it is granted. It cannot be transferred, because any kind of this maintenance of the woman, or now these days to elderly person, parents, is non-transferable, because this has been created by status. Maintenance is going to be given to wife or parents, because they are wife or parents by a status, and this status cannot be changed by the transfer. Okay. So, they cannot transfer their own rights in future maintenance. Okay. So, this future maintenance right is completely untransferable. This is for DD. Although the right to maintain is not transferable, arrears of maintenance is transferable. Then E, right to sue. Okay. This is the sixth exception, right to sue. The mere right to sue cannot be transferred. This means that the bare right to sue cannot be transferred at all. Right to sue for a definite sum of money can be a actionable claim and can be transferred, but right to sue for indefinite sum of money is non-transferable. It should be remembered that if there is a amount of money which is fixed in nature, okay, in that way it is transferable, but only mere right to sue, and in that suit whether you are going to win or going to lose is uncertain thing. So, in that case it is not transferable. But suppose I have a certain claim, okay, and within that certain claim amount is definite, then that can be transferable. So, in that way right to sue is governed. Illustration, it has been given here that A agrees to sell B a certain quantity of gunny bags to be delivered after a few days. Before the delivery, B transfer his beneficial interest in the contract to C. When A commits a breach of contract, C becomes entitled to sue A for damages for the breach of contract, because along with the transfer of beneficial interest, right to sue is also transferred, because it is a kind of actionable claim. So, if there is actionable claim in case of right to sue, then it can be permissible. Then that is the leading case, Durga Chandar versus Kailash Tunde, in which the Calcutta High Court held that a bare right to sue for means a profit cannot be assigned, as means a profit are antiquated damages and not a debt. Means a profit or produce of the property which is in adverse or unlawful possession of a person who is not entitled to possess it. So, the properties come back in the possession of the person who is legally entitled to its possession, he can claim means a profit from adverse possession. So, it is the social policy underlying this non-transferability of mere right to sue for unliquidated damages to prohibit the practice of gambling over litigation, because once it will start that we will give or we will transfer the right to sue to any other person, then it will be a kind of gamble that we will create a forged kind of right to sue, and we will create a forged litigation, and it will against the public policy, it will be against the justice delivery system. So, it will completely create the chaos in the judicial system itself. So, prohibiting this, it has been said that right to sue cannot be transferred. So, where the right to sue has merged in a decree, the right under that decree become assignable. So, right of misne profit under a decree is assignable, where the right to sue is connected with the business and the whole of the business is transferred, the right to sue is also automatically transferred. This Amiratham Kudum versus Sarnam Kudum. In this case, the property of a minor was sold by his father without any legal necessity or with the permission of the court. Therefore, the sale was void at the option of the son, who was the real owner. The Supreme Court held that anyone purchasing the property from the son on attaining the majority will be entitled to file suit for setting aside the sale made by father within 3 years of attaining the majority by the minor son. So, it was observed by the court that when the minor son transferred the property on attaining majority, his right to defeat existing adverse claim on the property was also transferred. Then this is the second last, that is clause F and G, public offices, salary and stipends. Public policy is that public office or salary or stipend should not be transferred. Why it should not be transferred? The reason is that, which has been explained by the court in Liverpool versus Wright. The court said that where the law assigns fee to any office, it is for the purpose of upholding the dignity and performing properly the duties of that office. And the policy of law will not allow the officer to bargain away those fees to a pointer or anyone else. So, this salary or this stipend is attached to the office is a kind of matter of pride and dignity, and it should not be the subject matter of trade, and it is about the integrity of office also. So, it should not be the subject matter of transfer, it cannot be treated as property. Okay. So, for that purpose it has been completely prohibited under Transfer of Property Act. Clause H is about the nature of interest, unlawful object and disqualification of transferee. So, clause H says that these are non-transferable, that is the nature of the interest affected thereby. That means, the property itself is like that, whose nature is against the transfer. Just like I told you about the well, when you are transferring the well, in that way the well is going to be transferred, but easementary right you cannot transfer, the nature is attached with that. Unlawful object is there, consideration is there, just like section 23 of the Contract Act, then it will fall in it. And to a person legally disqualified to be a transferee, if it is debarred by any law that the things cannot be transferred to him, then in that way it will be not transferred. The last clause is about the untransferable interest, which says that nothing in this section shall be deemed to authorize a tenant having an untransferable right of occupancy, the farmer of an estate in respect of which the default has been made in paying revenue, or the lessee of the estate, or the management of the court of wards to assign his interest as such tenant, farmer or lessee. It has been completely non-transferable. Then added in 1985 to remove the doubts regarding the non-transferability of occupancy rights. And under this clause, any tenant having an untransferable right of occupancy cannot transfer his interest to any such tenant. So, this section 6 overall give the list of non-transferable property which cannot be transferred at all, and it is very relevant under the Transfer of Property Act. It is important that it is the basic criteria which say that these are the non-transferable. So, it is all about section 6 non-transferable things. So, thank you all of you, and we will meet in next lecture. Thank you.